On May 10th, the Karen Reed trial continued with day 9 of testimony, continuing in the prosecution's case in chief. On day 9, we heard from 3 witnesses. First, we continued the cross-examination of Julie Albert, and then we got to hear from the homeowners of 34 Fairview Road themselves, Nicole and Brian Albert. And we got a special hearing about a matter involving alleged witness intimidation and whether or not someone should be kicked out of the courtroom. Let's get into it. We'll get into that hearing, but first I wanted to wrap up what we heard from Julie Albert on the stand. If you remember, at the end of day 8, defense attorney David Yannetti was in the middle of a pretty good role in her cross-examination about communications that she had with Courtney Proctor. And if you recall, Courtney Proctor is the sister of Trooper Michael Proctor, the lead investigator in this case. And already at the beginning of this cross-examination on day 10, she gets into a weird place right off the bat when she testifies that she can't remember using the word rarely in her testimony the day before.
Ma'am, you will recall yesterday I broached the topic with you of how often you and Courtney Proctor speak to each other over the phone. Do you recall that line of questioning?
Yes.
And when I asked you to describe the frequency of those phone calls, I didn't put any words in your mouth, did I? I didn't suggest how frequently they were. You came up with the word?
I don't really.
Well, let me put it this way. When I asked you how often you talked to Courtney Proctor, you could have chosen any word in the English language to answer that question, correct?
Correct.
What was the word that you chose?
Not often. I don't remember,
How about
honestly.
rarely?
Rarely, yes.
That was your word, correct?
It could have been. I don't really recall. I don't recall.
You don't recall telling this jury yesterday that when I asked you about how often you spoke to Courtney Proctor by phone, you said, well, rarely.
I don't remember.
What is your definition of rarely?
Not daily. Not daily, not. Yes.
Once in a blue moon?
No.
Rarely doesn't mean to you 67 phone conversations within a 7-month period, does it?
A 67 time period in how many, 8 months?
In about 7 months, 67 times.
It's not a lot. I wouldn't think it's a lot in 7 months.
3 times in one day? Is that rarely?
No, but that wasn't every day.
Now, as always, I do not know what the jury is thinking, and I want to know your impressions here. Do you think that she is BSing, not remembering using the word rarely the day before, or do you think that Yannetti is maybe getting a little bit nitpicky here? Because my personal impression is on day 8, Julie Albert used the word, and then Yannetti really hammered her on it. It was undoubtedly a very uncomfortable place for her to be in that cross-examination yesterday, and she likely regretted using it. And I don't know if you've ever been in an argument with a close friend, a family member, or a significant other, or what have you, when a word maybe tumbled out of your mouth and it resulted in another whole huge can of worms that you didn't anticipate. In my personal, admittedly anecdotal experience, I've remembered using that word the next day. Maybe even the next week, maybe even further, depending on just how bad of an experience it was. And it's because, generally speaking, there's a lot of emotion connected to that experience. And emotional experiences are often harder to forget, particularly when not much time has passed yet. So to me personally, Julie Albert saying that she doesn't really recall using the word rarely smells like she's just trying not to admit to an uncomfortable fact because she knows that she's about to get hammered on it yet again. But the problem is, when a witness does that in a trial, it only makes things worse for them. And now, hey, maybe there's absolutely nothing to the fact that Julie suddenly was talking on the phone with the sister of the lead investigator every few days over 7 months, starting when Karen Reed was arrested. And maybe the reason for how she's acting on the stand is actually stemming from her understanding of how things might look kind of bad to some people. But on top of looking like she's trying not to admit to having these communications in the first place, now she looks, to me anyway, like she's trying to play dumb about her testimony just the day before. And in my opinion, that just compounds the credibility issue here. And if there's really nothing behind these communications, like there really wasn't in all truth anything bad that happened in these phone calls, her behavior on the stand makes it look like she, in fact, was doing something or something was going on and it was really shady. Now, for my part, I still need a lot more evidence to convince me about the framing conspiracy claim that the defense is putting out there to get on board with that. But things like this do not help the prosecution and really only help to serve putting the defense's theory on that forward. So will the defense be able to put enough evidence forward to convince the jury on that claim? I don't know. Time will tell, but we'll see. In the meantime, let me know what you think in the comments down below. Now, after this, Yannetti dug a little further into those conversations between Julie Albert and Courtney Proctor. And it took some questioning, but he got her to admit that she did, in fact, talk with Courtney Proctor on February 1st, 2022, the day that Karen Read was arrested, and 4 times on February 2nd, 2022, the day that Karen Read was arraigned. And he more or less got her to admit that it could have been the case that they were in fact talking about Karen Read in those conversations around the arraignment on February 2nd, 2022.
In any case, regarding all of those 67 phone calls from February 1st until September 6th, do you maintain that during none of those calls, or any portion of those calls, did you and Courtney Proctor discuss the investigation into the death of John O'Keefe?
I do not remember.
Do you deny discussing that investigation?
I don't deny, but I do not remember.
All right. Well, you admitted yesterday, after having seen the records, that you spoke with Michael Proctor's sister for 12 minutes on February 1st of 2022. Do you recall that?
I don't recall the conversation, no. I don't. It was a long time ago.
I'm sorry, I don't mean to interrupt you. Finish your answer.
I'm sorry, it was a long time ago. I just don't remember.
Okay. But my question is, after seeing the records, you saw the phone call for over 12 minutes, correct?
Correct.
And you also remember that that was the very day that the police arrested Karen Read for this case, correct?
Correct.
The arrest of Karen Read on February 1st was pretty big news in Massachusetts, correct?
Objection.
Sustained.
You had seen that arrest all over the news, correct?
Correct.
So you certainly, given the day and the fact that it was February 1st and my client was arrested that day and you're talking to the lead investigator's sister, the subject of Karen Read's arrest had to have come up, right?
Objection.
Sustained. Ask it differently.
You certainly mentioned my client's arrest with Courtney Proctor on the very day that she was arrested and you were talking to Courtney, correct?
Correct.
Now, when we broke for the day yesterday, I had also asked you about the 3 phone calls that you had with Michael Proctor's sister on the morning of February 2nd when my client was arraigned, correct?
Correct.
And you recall that her arraignment was televised publicly, correct?
Objection.
Sustained. Ask it differently.
You saw her on the news being arraigned, correct?
Correct.
And one of those phone calls after, well, strike that. With regard to the 3 phone calls before the arraignment, you knew at that time that my client had been arrested the day before, correct?
Correct.
And you knew she would be arraigned in court that morning, correct?
Correct.
Certainly, when you were talking to Michael Proctor's sister on February 2nd, before her 9 o'clock arraignment, you were discussing the 9 o'clock arraignment, correct?
Can you repeat the end of that, please?
Sure. On February 2nd, the day that my client was scheduled to be arraigned in Stoughton District Court, we're talking about the 3 phone calls that you made to Michael Proctor's sister before that arraignment that very day. And my question is, certainly you were discussing the fact that she was about to be arraigned, correct?
Objection.
Sustained. Ask it differently, Mr. Unity.
Did the subject of Karen Reed's arraignment come up in any of those 3 calls on February 2nd, the day she was going to be arraigned, before her arraignment?
I don't remember exactly.
What about the 27-minute phone call that you had with Courtney Proctor at 10:58 a.m. that same day after my client was arraigned in court? Did you discuss the arraignment that had just happened?
I do not remember.
You had already testified that by 2022, you were no longer babysitting for Courtney Proctor's kids, correct?
I wasn't babysitting regularly like I was before.
So is it your testimony that you happened to be talking about babysitting on February 2nd for 27 minutes, the same day that my client was arraigned in Stoughton District Court?
I don't remember what I was talking about. It could have been about the kids. It could have been about anything. I don't remember.
Sure. And certainly it could have been about the publicly televised arraignment that had just occurred, correct?
Objection.
So I'll allow this, and then let's move away from this, okay? Can you answer that?
Yes, it could have been. Yes.
Did you tell Courtney Proctor during any of these 67 phone calls that you were a witness in her brother's case?
I don't remember.
Okay. Ms. Albert, you were at the waterfall on the night of January 28th, correct?
Yes.
Now, memory issues are always a possibility for any witness in a trial. We have talked about that at length throughout this trial, both in the live streams and in the recaps. But memory, or lapses in memory more specifically, can also be conveniently used when a witness doesn't want to admit to something or doesn't want to provide some kind of detail. And if the jury thinks that Julie Albert was in fact BSing about not remembering having testified to saying the word rarely the day before, that can have an impact on how much they believe her supposed lapses in memory here. And that's especially the case where a witness has already testified in the friendly environment of a direct examination with a lot of detail and a crystal clear memory. But you be the jury. What do you make of this? Let us know in the comments down below. Anyway, to further this theme of Julie Albert possibly being a secret mediator between the Alberts and Trooper Michael Proctor, Yannetti then turned to the subject of some phone calls directly between the witness and Michael Proctor. Particularly, he asked her about some phone calls between her and Proctor's personal phone. And again, this is the kind of thing that she could have testified like, yeah, I'm friends with his sister. We were talking during his off hours, I suppose, and he had questions about the case. But again, she had these lapses in her memory, and they may seem convenient to you, maybe not. But because she said she couldn't remember, Yannetti once again brought up phone records to see if he could refresh her recollection.
Did that refresh your memory about those 2 phone calls on February 10th?
I mean, I just read them, but I don't remember.
Okay. You called Trooper Proctor at 6:17 p.m., and it appears to be a 5-second phone call. Did you see that?
Objection, Your Honor.
Do you recall that Trooper Proctor called you back that same day at 6:21 p.m. and that you spoke for about 4 minutes?
Objection, Your Honor.
Do you deny speaking to Trooper Proctor for 4 minutes when he called you from his personal cell phone on February 10th of 2022 after you had been interviewed that day?
No, I don't deny it, but I don't remember it.
When did you get his personal cell phone number?
I don't remember.
Years ago?
I'm sure, yes.
Because you've known that family for a long time.
Yes, I have.
And as you testify here today, you can't remember what that phone call would have been about, correct?
No, I do not remember.
Anyway, after that, Yannetti turned to what Julie Albert testified on direct examination about the timing of her husband Christopher and her son Colin getting home that night. On direct, Julie had testified that Christopher got home at 12:10 a.m. and that Christopher got home about 10 or 15 minutes after him. This is almost exactly in line with what Christopher had originally testified to on direct examination before his cross-examination revealed that to be a little bit inaccurate. Now, Julie had also testified that she could never sleep when her kids were out, so she remembered that time here. But on cross-examination, Yannetti showed this to be inaccurate from the start, similar to what he did with Christopher. Specifically, Yannetti started out with the surveillance footage from the Waterfall Bar and Grill to show that Christopher left the bar at about 12:13 or 12:14 a.m.
Do you recognize that person?
Yes, I believe it's my husband.
Okay. If you can run that. Stop. Okay. Would you agree with me that your husband left the waterfall at about 12:13 and 46 seconds?
Well, yes, I mean, that's what it says on the screen.
Okay. So it was closer to 2:14 than to 2:10. Would you agree with that?
12:14, you mean? 2?
You know what? You're right. 12:14 then 12:10.
Yes, that's what I'm seeing.
Thank you. So if he's leaving at around 12:14, and by your testimony, it would have taken him he was walking home, you knew that, correct?
Yes,
He didn't have a car that night.
he did not.
And if it took him 6 or 7 minutes to get home, and by the way, let me strike that question. You had said it takes 6 or 7 minutes. Did you factor in the fact that of the weather that night for your estimate about a 6 or 7 minute walk?
Objection.
Can you answer that question? Is that what you said?
Yes, I didn't factor in the I don't know.
All right, so your testimony would be you don't know if it would have taken him a little bit longer, or anybody.
Anybody, everyone walks at a different pace.
Right, but whatever pace they walk at, given what you saw of the weather that night, is it your testimony that maybe it would have taken a little bit longer than the estimate because
It
of the
could
weather?
have.
Okay.
I
But
don't
in
know.
any case, let's leave it at 6 or 7 minutes. That puts your husband coming home at around 12:20 or 12:21, correct?
Correct.
All right. And that 12:10 estimate that you had, you made that estimate before having the benefit of the video, correct?
Correct.
Now, where were you within the house when your husband came home?
In my room.
Bedroom?
Upstairs in my bedroom.
All right. And you share a bedroom with your husband?
Yes.
And when was the first time that you saw him within the house?
He came up to the bedroom.
Okay, so you were in the bedroom and you see him appear in the bedroom.
Correct.
Did you hear the door open way down on the first floor?
Yes.
Okay. And it would have taken him maybe about a minute to get upstairs? It wasn't very long?
It wouldn't be very long, no.
Okay. And when he got upstairs, you noticed that he was in wet clothing, correct?
Yes.
He appeared to be cold.
Yes.
And he got undressed, correct?
Yes.
Did he brush his teeth before bed?
I think he got right into bed.
Okay, so you didn't see him brush his teeth or wash up.
No.
And were you in the bed when he came into the bed to go to sleep?
I was sitting up in bed, yes.
Were you reading or watching TV?
I was just sitting up in bed praying for my headache to go away.
Oh, okay. The migraine was still really
Yes.
bothering you. And you were suffering at that point.
Suffering? I had a headache.
Well, yeah, but a migraine headache, I would
Yeah.
imagine.
It was a headache, but I took medicine and I was waiting for it to get
waiting
better.
to kick in?
Yes.
Okay. And that's sort of what you were concentrating on. It's really kind of hard to read or watch TV or concentrate on anything when you have a migraine, right?
Okay. Yes.
Now, you would agree with me that your husband Chris was asleep when Colin came home, correct?
Correct.
And as a mother, you couldn't have gone to sleep until you knew your kids were home, correct?
Correct.
And Colin was the remaining child who was out there, which when he came home, that would given you license to go to sleep.
Yes.
Now, at the time that Colin came home with Chris sleeping, it's fair to say this was just an ordinary weekend night, correct?
How do you?
Well, in other words, you didn't know that anything tragic had occurred or was alleged to have occurred, correct?
Correct.
So it wasn't like you were paying attention to the clock at that point and recording your memories as best you could because you knew you'd be testifying later, correct?
Correct.
Which also explains the 12:10 estimate, right? I mean, you're being asked about, times that things occurred, and it was just sort of an ordinary day, right? So it's difficult to pinpoint times, correct?
Correct.
So again, there's a lot of attention being paid in this trial right now to the activity of Colin Albert, Julie and Christopher's son. It may not be clear to the jury what exactly that is. I say that because it's not entirely clear to me what exactly that is at this point, but there's something that the defense is definitely setting up here. So we'll see where that all goes. So that was Julie Albert. Next, we're going to talk about a little bit of a side quest hearing that happened in between the testimony of Julie Albert and her sister-in-law, Nicole Albert. So if you've been following this case for a long time, you might be familiar with the independent journalist named Aidan Kearney. Kearney, I'm not exactly sure how to pronounce his last name, to be honest. On social media, he goes by the name Turtleboy. From my very brief research on this, it looks like his efforts are one pretty big reason why this case ended up getting so much attention on social media and the media at large. He reportedly had heard about the case basically before anyone else started digging and has done a ton of videos going into the details for like the last couple years. And so part of his investigative efforts have apparently involved trying to speak directly with some of the witnesses in the case who we've heard a lot about. This includes members of the Albert family and the McCabe's and others. And so one development here that has resulted from all of this is that there is an allegation that Turtleboy has engaged in witness tampering on behalf of the defense as part of these efforts to communicate with them. Now, I don't know the details of the allegations beyond that. I can't give any sort of opinion as to whether or not the charge has any merit because I simply do not know enough about it. But now at the same time, there is a courtroom in this case that is open to journalists with valid press passes, along with the families of John O'Keefe and Karen Reed. And apparently this past week, Turtleboy was able to get a valid press pass. And on day 9, he was also able to get one of the extremely limited seats in the courtroom to report directly on the trial without having to watch on a live stream like the rest of us. Now, in light of this, because there are charges against him for the alleged witness intimidation, the prosecution apparently filed a motion to exclude him from the courtroom during the testimonies of those specific witnesses. And so that is what this particular hearing was all about. In the hearing, Turtleboy's attorney came forward, arguing that the First Amendment gives him a right as a journalist to be there in person to report on the trial. But on the other hand, the prosecution argued that the Massachusetts witness tampering statute meant that Turtleboy should be excluded from the courtroom during those specific testimonies because the witnesses themselves had concerns about him being there. And so the way that I see this whole issue, there's a couple things to look at here. Number one is the underlying facts of the witness tampering charge. And this is something that I already mentioned I don't have a lot of information about. What kind of actions occurred to give rise to these witnesses saying that they felt intimidated by Turtleboy? Was it just that he came up to them asking questions? Or did he show up to their houses, maybe with a weapon to talk to them about their testimony? Did he make threats to their lives? Did he make threats to maybe dox them in some way? These are some factors that can make a really big difference as to how this actually should be treated. Because if we look at a hypothetical situation where, say, there's a murder trial involving gang violence, and let's say that a witness saw the defendant do the thing, or so they say, but maybe months before trial, some other members of the defendant's gang come up to the witness and say, hey, if you testify in this trial and you testify to what we think you're going to testify to, we're going to hurt you or we're going to hurt your family. That's a huge issue for the judicial system. And I actually have known people who have testified as witnesses in criminal cases and faced intimidation directly by the defendant in that case. And I know how much that can really rattle a person. It can sometimes create a bunch of problems personally for that witness, and so testifying becomes an even bigger, scarier thing than it really even was to begin with. And so the judge, in any case, has a compelling interest in maintaining a fair trial to include these kinds of situations. But on the other side of this, Turtleboy's attorney made an argument for the First Amendment, and typically the First Amendment is a very, very strong argument to make. It's usually a pretty good trump card when it's actually applicable. And in this situation, the First Amendment rights of access to courtrooms, especially for the media, is in fact a great argument. But keep in mind, the First Amendment is also not limitless. There are a number of legal standards to use in First Amendment cases, and I'm not going to get into all of them in this video because that's really a video that would be entirely on its own. I'm pretty sure in law school, I even took a class that was just on the First Amendment. But here, I'll also say that I can envision a situation where an appellate court looks at this particular issue and says, trial courts have a compelling interest in maintaining a fair trial. And so, in this situation, the First Amendment doesn't win. But of course, I totally understand how you feel about this very issue personally may very well depend on what you know about these witness intimidation charges and whether you feel that they're appropriate or totally bogus and just intended to sideline Turtleboy in some sort of legitimate journalism efforts. And I will say, my personal unease in this subject does come partly from not knowing the underlying facts, but also from the fact that there is this attempt to exclude him when he's been charged with witness intimidation, but not yet convicted. Because, of course, a charge does not necessarily mean that someone is guilty of what they have been accused of. But anyway, here's ultimately what Judge Cannone decided on this issue.
So, Mr. Bradel, I agree with you that Mr. Kearney is certified by the Office of Public Information pursuant to SJC Rule 119, and that he has a right to be here today. He arrived timely, and that he is registered. I have honored that 119 registration today, and I will continue to honor that. However, my role in this case, Commonwealth versus Karen Reed, is to assure that the defendant's constitutional right to a fair trial are honored and upheld. And because of the chilling effect that Mr. Kearney's presence, I find, will have on the witness's testimony, I'm going to excuse him while the named witnesses in the Commonwealth's motion, Julie Nagel, Christopher Albert, Colin Albert, Michael Proctor, Jennifer McCabe, Matthew McCabe, Brian Albert, and Yuri Buchanan. And the Commonwealth also today requested Nicole Albert because of the incidents that reportedly have been held at her home. I'm going to excuse him during all of that testimony. Now, in my media order, if you have it, I'm sure your client has it because they're handed out to the press. Under number 1, I say that anyone leaving the courtroom to the media during the trial proceedings may lose their seat and may not be permitted re-entry unless there is available seating. That will not happen to Mr. Kearney. I will not take away his seat today. For other witnesses who are not subject to this order, that seat will remain empty. No other person of the media will be able to take that seat in his absence. Okay?
Your Honor, one last thing, if I may, just came to me as I was standing here. Extension in same regard as to Nicole Albert for the address would be Brian Albert Jr., son of Brian and Nicole Albert, lives at the same address.
It's for the same reason, so Brian Albert Jr. All right, so those are my findings, Mr. Bradel. It should give you enough to seek appellate action if you wish. Okay? All right, thank you for being here. All right.
So Judge Cannone said that she was most concerned with the quote-unquote chilling effect on the testimony, and that's why she excluded Turtleboy from the courtroom, specifically when these other witnesses are testifying. Now, if Turtleboy does decide to appeal, this would be an interesting First Amendment issue, in my opinion. But We'll see. Anyway, then we got to the testimony of the homeowners of 34 Fairview Road. And first up was Nicole Albert. On direct, she also testified that she was at the Waterfall Bar and Grill on the night of January 28th, 2022. And her testimony was basically the same as everyone else's so far on that part. John O'Keefe was there, Karen Reed was there, everyone was happy, everyone was vibing, etc. Then Nicole testified that around midnight, she had invited her sister Jennifer McCabe and Jennifer's husband Matt to come over to 34 Fairview Road. Nicole testified that at midnight, her son Brian Albert Jr. was turning 23, and so she invited the family members in the group to come over and wish him a happy birthday. Jennifer apparently then turned around and invited the whole group to come over, which Nicole said that she really didn't have a problem with. Nicole then testified that when she got home, her nephew Colin Albert was just leaving after dropping by to wish Brian Jr. a happy birthday. Now, on direct examination, Nicole came across as nervous but pretty straightforward. She seemed to be basically a sympathetic witness. But Nicole's cross-examination was done by defense attorney Elizabeth Little, and this is the first time that we saw Miss Little in this trial from the defense team. Anyway, in the cross-examination, the subject of Colin came up and seemed to establish a pattern of adult members in this case and in this family who are maybe conveniently omitting certain information about his activities that night.
And you testified that you spoke to Trooper Proctor on February 3rd, 2022. Is that correct?
Yes.
That would be 6 days after this occurred. Is that right?
Yep.
And that's the very first time that you were ever interviewed by Massachusetts State Police.
Yes.
Correct?
Yep.
Aside from that sort of conversation you described with Sergeant Lang.
Yeah. Yep.
Okay. When you spoke to Trooper Proctor on February 3rd, 2022, you left a lot of names out of individuals who were present at your house on the morning of January 29th, 2022. Isn't that correct?
I'm not sure who was left out.
Did you tell Trooper Proctor that your son, Brian Albert Jr., was home that night?
Was home the night of his birthday, or what do you mean?
Yes, the night of his birthday.
Well, yeah, he was home with his friends.
Did you tell that to Trooper Proctor?
I assume I did.
So if it wasn't in his report, that would have been his mistake?
Objection, Your Honor.
Sustained.
Did you tell Trooper Proctor your daughter, Caitlin Albert, returned home with you after the waterfall?
I believe so.
Did you tell Trooper Proctor that your son had 2 female friends at your house when you arrived?
I believe so.
And notably, did you tell Trooper Proctor that Colin Albert was present at your house?
You know, I probably didn't, because anytime I was questioned about who was there, to me it was who was there afterwards, hanging out from like the 12:15 point on. I didn't consider Colin as being there because I literally crossed paths with him. He left, and I didn't consider him being a part of the group that was there.
Were you asked who was at the house that night?
I assume he asked that, but I also didn't mention the people that my son had previous, because I didn't consider them as part of the people that I was with when I got home.
You never mentioned Colin Albert to Trooper Proctor, correct?
Correct.
And you never mentioned Colin Albert to Sergeant Lang.
Correct.
Ms. Albert, you knew that if you gave Trooper Proctor the name of your nephew, that he would have to interview him, correct?
Objection.
All right, I'm going to sustain that objection.
You didn't want your kids or your nephew to have to tell the police what they saw, what they heard, and what they did that night. Did you?
Objection.
I'm going to allow that. Is that true?
That is not true.
But you never told Trooper Proctor about Colin Albert.
I didn't mention Colin because I didn't consider him as part of the group that we were hanging out with after the waterfall, because he left as soon as I walked in. I didn't even think of him.
Didn't even think of him.
No.
Didn't think it might be important for the state trooper who was investigating this case to know the individuals who were leaving at the precise time that Mr. O'Keefe and Ms. Reed arrived at the house.
Objection.
Sustained.
So if the question that she in fact was asked by the police officer in the interview was who all was there that night, and she omitted that Colin Albert had been there, that can look a certain kind of way to some people. And again, this is the kind of discrepancy that only looks worse because of the fact that it's coming up first on cross-examination as opposed to first on direct examination. If prosecutor Adam Lally had been the first to speak about it, it wouldn't look as much like Nicole was trying to hide something. Addressing the bad facts on direct examination takes the sting out of them, so to speak. And this is something that the prosecution has done consistently throughout this trial so far, is to basically wait for the defense to bring up these bad facts as opposed to getting ahead of them so that they can potentially reframe them from the prosecution's perspective. Now, another thing that Nicole Albert testified to on direct examination was the ordering of when certain people left their house that night. She testified that first Brian Higgins left at around 1:30 in the morning. Then she said that Jennifer McCabe, Matt McCabe, and Brian Jr.'s friends left around 1:45 or 1:50 a.m. in the morning. Then she said that Caitlin Albert left closer to 2 a.m. But on cross-examination, it came up that originally she had said in the police interview that Caitlin was actually the first to leave, not the last. Now, whether this inconsistency is important might be up to interpretation. I have a feeling that the defense thinks it's important not just because it's an inconsistency, but also because maybe there's something important about when Caitlin Albert actually left. But we will see as we move along in this trial. Now, there are also a couple other things that Nicole Albert testified about that were also important. One of them was the sale of 34 Fairview Road. Nicole testified that she and her husband had been talking about selling the house since the end of 2021, since their kids were grown and they were really basically looking to downsize. So she says that that's the reason why they listed their house for sale, something like 4 months after this whole incident happened. She, of course, maintained that the sale of the house had nothing to do with John O'Keefe's death. And I know that there are a lot of people who point to the fact that it was listed at like $950,000 and then sold for $50,000 under the asking price in a very hot market, and a number of other details. But none of that came up in her direct or her cross-examination. So as far as the evidence at trial is concerned, I don't know if the jury is going to see this part as really a big issue. Now, the other big thing that she testified about, however, was Chloe, the German Shepherd. She testified that they had had a German Shepherd mix for a number of years. I had thought that this was a retired canine, but I think that may have been a mistaken impression that I had. Anyway, Nicole said that Chloe was allowed everywhere in the house and really didn't have a problem with strangers. At night, Chloe slept in the bedroom with Nicole and Brian, and they would let her out into the backyard at night to go and relieve herself. And so she testified that on the night of January 28th / morning of January 29th, at one point when people were over, Chloe was led into the backyard just for a few minutes. She came back in, hung around, and eventually slept upstairs. Basically all uneventful stuff. On cross-examination, however, again, information came out that probably could have sounded not as bad if it had been addressed on direct examination. You see, apparently there was an incident with Chloe where she had been in the backyard and then managed to get out. And when she did, she apparently attacked another dog that a neighbor was out walking on a leash. And in the process of trying to get Chloe off her dog, the other dog owner apparently ended up also getting injured and needed to go to the hospital for treatment. Now, there was a discrepancy between the defense and the witness as to whether one woman or two women were injured as a result of this incident, but regardless, it still doesn't sound great. And that's especially because the defense has hinted at the claim that Chloe may have been a part of the reason why John O'Keefe died that night. And another thing that hints at this is the fact that the defense on cross-examination brought up the fact that Chloe was actually rehomed to Vermont in the months that followed John O'Keefe's death. Nicole Albert insisted that it had nothing to do with that, but we'll see how the jury takes all of that information. Nicole also testified that she has always made Chloe available for any kind of testing related to this trial. And now, because of that statement, the defense definitely tried to dig into that sort of claim. And that's because my understanding is that the defense has tried very hard to get DNA testing from Chloe over the past months, maybe a year or more. And apparently they were completely unsuccessful despite those attempts. However, defense attorney Elizabeth Little was not able to pierce into that subject in front of the jury because the judge kept sustaining the prosecution's objections to it. And now, one final thing on Nicole Albert's testimony. She testified that the next morning she woke up when her sister Jennifer McCabe basically barged into Nicole and Brian's bedroom around 6 or 6:30 a.m. to tell them about what had happened to John. Nicole testified that they actually rarely lock their front door, and so that's one of the reasons why Jennifer was able to just sort of walk right in. And so Nicole said that she and her husband Brian woke up then and peered out the window from their bedroom and saw some cop cars, maybe a fire engine, and that's about it. But she said that prior to this, she hadn't heard any kind of commotion going on outside. On cross-examination, it looked like this happened more like 6:45 a.m. as opposed to 6 or 6:30, according to video surveillance. But that doesn't really seem to be much of an issue here with this part of the testimony. A bigger issue for the defense was the fact that apparently Jennifer McCabe had called Nicole 3 times earlier that morning, but Nicole denied talking to her. So the defense presented Nicole with her phone call records, and here's how that played out.
Ms. Albert, what about the 2 calls that you received from your sister at 6:07 and 6:08 a.m., which were answered?
I never answered any phone calls from my sister that morning.
You're aware that the Cellbrite records indicated that you answered 2 calls from your sister.
Objection, Your Honor.
The,
And 6:08 a.m.
the objection sustained.
Your Honor, may I approach the witness?
Okay? And you can go back and ask a question, and let's see where we go with this, okay?
Ms. Albert, do you recognize this document?
Recognize it?
Do you know what it is?
Well, yeah, I see what it is.
Does it refresh your recollection as to the 2 calls you received on the morning of January 29th?
It says here 2 calls were placed.
Okay, don't read it, but you were asked a specific question. So if you could answer the question, please.
Does that refresh your recollection to the 2 calls you received from your sister on the morning of January 29th?
She may have placed those phone calls to me, but I never answered them.
You received a call from Jennifer McCabe on January 29th at 6:07:42 a.m. that lasted for 9 seconds, correct?
She may have placed a phone call to me. I never answered it. I never spoke to her that morning.
You also received a second call from your sister at 6:08:17 a.m. that lasted for 7 seconds, correct?
Objection.
Go ahead and answer that.
It says that, but I never answered a phone call from my sister Jennifer that morning.
You're aware that cell phone companies have what are called tolling records, correct? That show if there's a voicemail or something of that nature.
Objection, Your Honor.
Sustained.
Ms. Albert, it's your testimony here today that you never spoke to your sister that morning.
I never spoke to my sister on the phone that morning.
Who else was in your bedroom that morning?
Me and my husband.
You and Brian Albert were the only 2 individuals who could have answered those calls that morning, correct?
We're the only 2 people in the room, besides the dog.
And at 6:07 a.m., someone had a 9-second call with Jennifer McCabe, correct?
Objection.
All right, sustained. And you've got more for this witness, I imagine, Ms. Little?
Yes, Your Honor.
Okay, so we'll take the luncheon recess, folks. It's 1 o'clock.
So did Nicole Albert pick up these phone calls, or is the 9 seconds or 7 seconds marked in the call logs signs that Jennifer McCabe maybe left her voicemails? Initially, I did find it weird for them to have very specific lengths and figured she must have picked up. But after some thought, I'm honestly on the fence about whether these went directly to voicemail or not. Anyway, that was Nicole Albert. Next up was the other homeowner of 34 Fairview Road, and that was Brian Albert, Nicole's husband. Now, his direct examination was very similar to Nicole's. On the evening of January 28th, he was also at the Waterfall Bar and Grill with everyone else. He saw John and Karen there. He knew of John, but didn't really know him personally. Everyone was having a good time. They were all vibing. They were all drinking, etc. Then he says that they went to 34 Fairview Road for his son Brian Jr.'s birthday, and he very briefly saw Colin, he said. Brian testified about Chloe, the German Shepherd, and how they briefly let her out in the backyard backyard to pee. One thing that was different about his testimony, though, was that he did mention one point when he and Brian Higgins walked away from the group together while those people were gathered at 34 Fairview Road.
And at any point in time, while this was all going on, did you, other than your situation with the dog, was there any point in time where you were not with the group in the kitchen dining area?
No, I was there basically for the whole night, except I think at one point I may have shown Brian Higgins some photos that were in my son's room that were upstairs.
And what kind of photos are we talking?
So my son Jack, who's one of the twins, was in the Marines, or is in the Marines, and we had put some plaques and some stuff in his room upstairs, and Brian Higgins was prior military, as am I, and I thought he would want to see the photos, so I had him look at them.
And for that period of time that you were outside of sort of the kitchen dining room area looking at the photos with Mr. Higgins, about how long a period of time were we talking?
Very, very quickly, 2 minutes, maybe 3 minutes.
Now, I don't know exactly why the prosecution wanted this occurrence explained, but I have a feeling that it's going to come up on cross-examination. Specifically, it just kind of feels like there may be some significance to the defense to the fact that Brian Albert and Brian Higgins spent some time that evening away from the rest of the group while they were there at 34 Fairview Road. But that's going to have to come on day 10 because the jury only got to hear his direct examination so far. Cross-examination will pick up on the morning of day 10, so we will see where this goes really. And with that, that's what I've got for day 9. 2 weeks into this trial now, I'm really not convinced that anyone intentionally killed John O'Keefe. I really have not seen enough evidence to be able to conclude that the prosecution at this point has met its burden to prove beyond reasonable doubt that Karen Reed murdered John O'Keefe, or that she even drove while impaired that night. But on the flip side, I also haven't seen enough information to really be able to conclude that the Alberts somehow killed John O'Keefe and worked to frame Karen Reed for it. So far, the evidence doesn't even convince me that John walked through the door of 34 Fairview Road, but it also doesn't convince me that Karen killed him either. And on the balance, that would lean towards an acquittal because remember, the burden of proof is squarely on the shoulders of the prosecution. Now, do I think that the Canton Police Department did a blusteringly terrible job investigating this case to the extent that they may be deserving of being entirely lampooned? Absolutely. Do I think that there are a number of witnesses that look incredibly shady after their testimony in this trial? Also, yes. But beyond that, there is still so much trial left in this case, and I am looking forward to seeing the rest of this evidence play out. But those are my thoughts. What do you think? Do you think that Julie Albert is some kind of maybe secret mediary between the Alberts and Trooper Michael Proctor? Do you think that there's more to Colin Albert's activities on the night that John O'Keefe died? What do you make of the sale of 34 Fairview Road and the rehoming of Chloe the German Shepherd? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of the Karen Reed trial, both in daily recaps and in gavel-to-gavel live stream coverage, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you in the next one.